Or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. I am not
allowed to
required
make
to
the
give you
record
that
at all, Your
opportunity,
Honor?
sir.
I'm not allowed to make the record at all? As I just let you did, because some of the issues has been... Some of the issues has been...
You have told me what you want to do. I've told you you can't. I've addressed the request.
Some of the issues have been me over-talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record and it's unlawful law. You haven't shown one time that is lawful for you to do what you've been doing as far as your rulings.
Once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an opportunity, if convicted, to raise every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights. as I have the right to do under the First Amendment and under the Sixth Amendment. You can't just disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States Constitution is null and void. There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution. You
Mr.
know
Brooks, I
this.
direct your attention to State versus Anthony. Although that case dealt with the right to testify.
Okay, so
its
we're not talking
reasoning
about
is
the right to
equally
testify.
applicable.
We're talking about the closing arguments, correct? We're not talking about testifying, which you
Mr.
already
Brooks,
made a
I'm
ruling
not going
on.
to delay
You
any
already
further
made a
the
ruling
closing
on,
arguments
but
of
Your
the
Honor,
parties.
with all due
I will
respect,
address your further request
with all due
once the
respect,
state.
you already made a ruling about testifying. Did you or did you not?
Mr. Brooks.
So we're talking about now, we're talking about closing arguments that I said it's my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
You
we are
can't
at the stage
tell
of
me
the
I can't.
proceedings where it is the state's burden of proof where they get to make their closing argument.
We're talking
first.
about me though.
I understand that, sir, but
I'm going to inform
your
them of the
conduct
truth.
right now is delaying
I'm not intended
the court's
to delay
intention
anything.
of moving
I let
forward
you,
with
Your
the
Honor,
closing argument.
I just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted to say. I let you make the record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by
I'm
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues.
How-
From my
how am I-
perspective, that is in an
how am I
attempt
being
to
dishonored?
simply
How am I being
delay
in
what we're
dishonor?
doing.
How am
So
I being
you are
in
put
dishonor?
on notice. I am done dealing with
How am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have
I'm
I not
going
preserved
to
my
address
rights?
this further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
You
made
can
my
hold me in
determination.
contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments,
Apparently
but you do
don't.
not
Apparently
want to
you
follow
don't,
the
Your Honor,
rules.
because all I said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir,
or
and
I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say. But I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're not
day, though, Your
relevant.
Honor. This
They're
is a
not-
whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury. But
Okay,
you're right.
but-
I will wait and see.
Your Honor, it's
But
still...
I need to get going.
It's still
and I'm going to,
unconstitutional for
sir.
you to
So
tell me that
you
I don't
need to
have
be
the First
quiet.
Amendment right that I preserved, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserved.
the jury brought out. I expect that you will be respectful, courteous, and quiet.
Or I'll be
And
held
when
in
this door
contempt.
opens,
Or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now. Because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even,
coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute
you
me.
to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt. Hold me in contempt. I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here, however, the jury is still in the hallway. I'm gonna give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether
Your Honor,
he
I
agrees
haven't-
with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the
not,
way
I'm
that
not
you have through
disrupting
the
the
course
proceeding.
of
You just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury. I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you
present.
to be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The
satisfaction.
record
It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you going to
follow the
answer
court's
questions as a public
requirement?
servant on why you're making up laws that are not in the Illinois versus Allen and never utilized
the
the
jury
mute button
can
and
go
never
back
said
to the
anything
jury
about a
room.
mute
Thank you.
button?
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not?
argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant-
invite you back over when it's time for your
You
closing
can't invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other courtroom when I
and
can
you'll
do
mute
so
me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me.